Law Firm webinar on the California Contractor Guide. We'll be diving into specifically Business and Professions Code Section 7159, those requirements that impact the home improvement contract. If you are a general contractor, this webinar will most likely have a lot of pertinent information you can use to apply and review your contract to see if you are in compliance with Business and Professions Code 7159. Let's dive in. To introduce myself, my name is Elaine Huang, and I am an associate attorney here at Blake Law Firm. Our office represents clients in both transactional and litigation real estate disputes. So on the day-to-day, we're representing clients who are general contractors or owners, tenants, as well as a variety of other parties in real estate matters. I'm very excited to talk to you today about this compliance because we see it being a hiccup in a lot of contracts, and with the amount of consequences that a general contractor could be exposed to, it's important to rein in the exposure and take a look at what exactly is an obligation that all these agreements provided by home improvement contractors must have in the terms. Let's get compliant by starting off and looking at why contract compliance is important. As I was just saying, exposing yourself to liability of non-compliance for Business and Professions Code Section 7159 can have drastic implications. For one, the contract would apply to Business and Professions Code Section 7159 if the materials, the labor, and the services being provided are over $500. In this economy, most likely the labor plus the materials on property are going to end up over $500, thereby triggering this section and triggering this list of consequences if you are not in compliance. For one, you may be subject to the Contractor State License Board's fines. For two, that may lead to suspension or revoking your contracting license. But most importantly is that the contract itself may not be enforceable if the terms under 7159 are not being met. What exactly are those terms? We want to take a look at who must comply, because if you are required to comply, this presentation on what those terms are going to be highly pertinent for you. First and foremost, the definition of home improvement contract under 7159B outlines that this agreement between contractors and owners/tenants that is for the purpose of providing labor, services, or materials, whether that's the installation of a solar panel or the fixing of a roof or the ordering of a sliding door. All of those different examples qualifies as a service that, if put into a contract, would likely be a home improvement contract, as long as all of those services, materials, and labor added together is over the $500 threshold I was sharing with you just minutes ago. It is important to note that the home improvement contract must be in writing. So if you are providing labor or services or materials that exceeds the price of $500, you must have those terms written in a home improvement contract in order for it to be sufficient under this code section. The foundational requirements of the agreement lies in things as nitty-gritty as how large the font size of the language in that agreement. For one, you want to double check that the point size of the font being used is at least 10-point typeface. Second, if you have headings like home improvement or scope of work, those headings, not only must they be in 10-point boldface, but they also must be clearly visible. So If you have a heading like home improvement, it shouldn't be mixed into the paragraph with a colon right after it, non-bolded. Otherwise, your heading isn't meeting the standards of Code Section 7159. And also, basic information about your company, like the name, the business address, the contractor whose license is associated with the general contracting business must be provided as well. If your business is using a salesperson and that sales rep has a registration number, you should include that as well in the agreement. Then there is the scope of work as well as the timeline performing that work. You will see that under this specific code section, there are requirements that specify the contractor provide an approximate start date and approximate completion date, along with a detailed description of services and materials to be provided during that approximate start and completion date. So, for example, if you are providing services such as installing and deinstalling a solar panel system while the roof gets fixed, you must specify in detail the dates that you anticipate starting, not just, here's a bad example, 2025, work on roof, finish job by end of year. Those are not approximate dates because you're just giving a general year and you're not specifying what services are going to be provided on that roof. Work on roof would fall under the very vague side of the spectrum when it comes to describing the services and materials you're providing, whereas a good example on the other side of the detailed spectrum providing descriptive services will look more along the lines of approximately starting work on January 22nd, 2026, providing services of uninstalling solar panel system, providing new roof shingles that have a warranty under specific company, and then on January 27th, 2026, reinstalling the solar panel system and completing all roof repair work by January 31st, 2026. That would be a good example of a descriptive service and a clear approximate start and completion date. Lastly, if your agreement has other specifications, such as you're installing a solar system and there's a warranty part of that solar system, that warranty may have a physical document for you to provide to the homeowner. In that instance, you may want to specifically incorporate that warranty as a part of the agreement by listing out the specifications of what is part of the deal, the agreements that are part of the deal, the services that are a part of the deal, and the materials that are a part of the deal. It's better to have all of this encompassed in the language so that you have the writing to support your position, as opposed to later on being in a he said, she said situation where the parties are relying on oral promises is often a slippery slope for ambiguity in each party's in obligations, and any ambiguity in obligation may be a slippery slope for an escalating dispute that can open a can of worms in litigation. Then we have the terms regarding the pricing and the payment procedure. The total price of the contract must be under a heading specifically titled contract price. And you may remember from my previous slide that contract price, if a heading, must be bolded, not just 10-point font. So it's important to remember how these various terms work with each other in order to create a compliant agreement. Second, there is a specific requirement that legally caps the maximum down payment a contractor can receive. That is 10% of the contract price or $1,000, whichever is less. So even if you have a contract that's more than $10,000 and 10% of that contract would technically be more than 1,000, the legal limit that a contractor is allowed to take for the down payment is $1,000 if that happens to be the lesser amount compared to 10% of the contract price. And then if there are progress payments along the timeline prior to the completion of the contract, Section 7159 has very specific requirements of how that work must be described and completed before each payment. So prior to the completion of that progress payment work, the owner or the tenant will receive written description of the services to be provided, and upon the completion of that specific work, then a progress payment may be issued. And that money that is issued to the contractor for that progress that has already been performed cannot exceed the value of what work was actually provided to the homeowner. So, for example, if a contractor provides a progress update saying that all the approximate work from January 21st to 23rd has been completed, and on the 24th, they anticipate a certain amount of work to be wrapped up, that contractor who has not provided the actual value of the work cannot receive the payment for progress work that hasn't been provided yet. So keep that in mind if you're collecting progress payments is for work that's actually been done. And then we have our mandatory notices, the language in the fine print that contractors should make sure any agreement for materials and labor over $500 should see these specific terms in their contract. First and foremost is the 3-day right to cancel. That gives the homeowner the right to cancel the agreement within 3 days if they enter into this contract and so choose they don't want your services anymore. Secondly, it is the mechanic's lien warning. This is language in the agreement that educates the owner their potential liens that could be recorded against their property by the general contractor if work is performed, materials are provided, but no payment is tendered to that general contractor who has provided the work already. Next is the Contractor State Licensing Board information that gives a consumer details on how to reach out to the CSLB if they choose to request more information on the contractor who is doing their work, and just generally to inform the homeowner/consumer that the CSLB exists. Lastly, it's the insurance disclosures that are required because general contractors are legally required to have workers' compensation and general commercial liability insurance. So that's just more transparency in the fine terms for homeowners who want to access that transparency to information. Now, what happens when there are changes along the progress of the contract and a homeowner sees something that's done but potentially requests extra work from the contractor? Because that work may be extra, the scope may have changed, and as a result, the original home improvement agreement no longer identifies all the scope of services and materials being provided. Therefore, the golden rule is that all change orders must be in writing and it must be done before the work begins. This is because once you're doing the work and you're changing the services you're providing, you are putting yourself in a position of exposure to liability because the homeowner has a contract that in black and white writing says you were supposed to perform a certain service. Now those services have changed. You're relying on potentially oral instructions or oral promises, and that puts you in a position of vulnerability where The general rule is if it isn't in writing, it didn't happen. So you don't want to put yourself in a position where the scope of work you're performing has changed, but the price on paper has not. And the enforceable contract is for a price that was provided prior to you accepting the change of scope in work. And that exposes yourself to potentially performing additional labor that won't be compensated for in the future if the homeowner says something along the lines of, I didn't ask for those improvements, I never agreed to the terms of a new contract price, or if I had known your labor would cost that much, then I never would have made that promise, and we don't have anything in writing supporting it. So, just a heads up to keep in mind these potential liability exposure scenarios that could unfold if you don't have the changes of extra work or the changes in scope put into writing. Here are some of the common pitfalls that, as a litigation real estate firm, we see and are providing some tips on how you can avoid some of the most common mistakes that people who issue home improvement agreements run into. First and foremost, it is using an outdated template contract that's on the internet. Although it's wonderful to be able to access information on the internet, sometimes the contracts that are provided for free on various blogs or websites may not be updated to code. So, as the law continues to change, that doesn't necessarily mean the people who are providing these free templates are updating their free resources in order to make sure it's compliant with the law as the law evolves. Second, it is failing to update the contract when the scope changes. Just like I was saying earlier, if you don't have writing to protect yourself when the scope has changed and you perform the work, you may put yourself in a position of asking for money from a owner who denies asking you to change the scope. And in that scenario, you wouldn't have the evidence to prove that the other party agreed to an updated contract price or the new materials that you were providing. Perhaps they're more expensive, they're higher quality, and now the homeowner only wants to pay you for the materials that were promised in the original contract scope. So, failing to update your contract can lead to a difficult position later on when you are trying to enforce that contract if you don't have later changes in writing. Lastly, it is over collecting on down payments because there is a clear black and white rule on how much a homeowner can pay in a down payment for a home improvement contract. That is 10% of the contract price or $1,000, whichever is the lesser. So again, even if a general contractor enters into a contract with a homeowner for a $50,000 contract, and normally 10% of that may be higher than the 1,000 legal limit, your legal limit is still the lesser of 10% of the contract or $1,000. So, as a general contractor, you want to avoid that common pitfall of over collecting a down payment that's higher than the legal limit. Now that you've received all of these tips on how to make sure your agreement is enforceable and compliant with Section 7159, it may be a good time to check in with a real estate attorney and have a professional who sees these agreements on the day to day look at the specific language in your agreement to make sure that the current legal standards are satisfied. As the law is evolving and the requirements may be changing, it's important to be aware of what those current requirements are and to make sure your agreement is compliant as the law evolves, which is why we're here and we love to learn about real estate law and to educate others on how they can make their real estate potential disputes less likely to occur with prudent actions like reviewing your contract and making sure all of the required terms are in there before you get involved in the middle of a contract dispute and before someone claims that your agreement is unenforceable. If you have any questions or if you would like to look at our website for a compliance checklist regarding what I've discussed today, feel free to look up www.blakelawca.com/7159 for more information. It has been a pleasure speaking with you today, and I look forward to potentially seeing you on another webinar. If you have any other questions, you can reach out to our office today using the info@blakelawca email. If you have additional interest in the topic and would like access to even more resources outside of today's webinar, feel free to look up on our website the supporting material we have prepared for you. It has been a pleasure speaking with you, and until next time, I hope you have a wonderful day. Take care.